Welcome to Community Spotlight. I'm your host, Mike Babakhanyan, and on this show, we love to dive into the local communities, bringing you the businesses and entrepreneurs that truly shine and bring our cities to life. And today, if you're thinking about becoming a landlord, or if you are a landlord, this is a must-watch episode. Without further ado, I would like to introduce Raymond Hovsepian, attorney at law. Raymond, welcome to the show.
Thank you, Mike. Thank you very much for having me.
Absolutely. So Raymond, why don't you share with our viewers a little bit about who you are, your experience, and how long you've been working with landlords and tenants?
So my name is Raymond Hovsepian. I've been a landlord-tenant attorney for about 28 years now. I primarily represent landlords in litigation.
Okay.
I have a consulting business as well with landlords before they purchase or after they purchase. And I advise them about the legalities of what they're trying to do, how they want to make their investment work. So that's primarily what I do in the area of landlord-tenant law.
Impressive. Well, Raymond, I have a lot of great questions to ask you. And I know when attorneys are asked a question, common response is, it depends. So let's just have some fun. Let's go through the questions and let's see where it takes us. Sounds good?
I love it.
All right. So what are the most common legal challenges that landlords are facing today?
I would say the most common challenge is trying to navigate the different laws as they pertain to the different governmental laws. For example, you have city laws, you have county laws, you have state laws. So all these laws, they overlap. And sometimes landlords have a misconception that all they have to do is follow one set of law that they have known for many years. But things have changed, laws have changed, legislation changes every couple months, depending on how the political winds blow. So you have to be always on top of the new developments in the legal field so that you know what you can do and what you cannot do.
Okay, makes sense. All right, so my next question is how do local ordinances like LA impact landlord-tenant relationships?
So the new laws in the city of Los Angeles, for example, are all designed for the benefit of the tenant. Because, of course, tenants have a lot of political voting power.
True.
So you will hear a lot of local leaders talk about tenant protection or giving tenants the rights of having lawyers in court to try to fight evictions. And one of the major reasons why they do that is not only because of the sheer number of votes available to them from tenants, but also because they believe wholeheartedly that homelessness is caused by evictions.
Okay.
Some people share that feeling, some people don't. I don't really know about that, but that's what they use as an excuse to be on the side of the tenants and sort of tip the scales towards the tenants. So in the city of Los Angeles, you have to be very careful as a landlord. There are a lot of hoops that you have to jump through in order to get to where you want to be, how you want to make your investment grow. So it's very important to have somebody on your side knowledgeable enough to tell you the facts so that you don't make any missteps.
Exactly. Keep you up to date on all the changes.
Exactly.
It's funny you say that because I read an article yesterday in Burbank, 60% of the residents are tenants. Okay, and they're trying to make it more stricter now in favor of tenants.
Yes.
So that should be interesting.
Yes, there's a growing number of landlords who are trying to renovate the properties, major renovations.
Exactly.
So long-time tenants are being displaced because of these renovations.
Correct.
So there are movements everywhere in Burbank, in Glendale, in LA, in different cities where there is a moratorium on major renovations being made by landlords. So as a landlord, you have to know what you need to do because every time, the constituents call their city council people and say, hey, I'm being evicted. My landlord is telling me that I need to move because he's going to completely remodel, gut my building. So what do I do? So that's why it's very important to keep up to date on the laws and what's going on with city council of different cities.
So when in Burbank, for example, or Glendale, the landlord has to show the tenants the permits that they paid for.
Yes.
Proof of they're actually going to do the remodeling, correct?
Yes, so you have to have permits already done, and you have to provide a copy of the permits to the tenant. You also have to provide the tenant with a scope of work and why the work cannot be completed in less than so many days. Okay. It used to be 30, now they're changing it to 60. I've heard 90 even. The state is thinking of making it harder for landlords to take a property and just claim renovation so that they can evict the tenant. So because they think, oh, you know, they're just doing it to raise rent.
Correct.
Go around some of the laws. So it's very important to know what documentation you need in order to get started on major renovation types of cases. So it's permits, it's scope of work estimates, and of course relocation fees and how much those should be. And those are changing all the time.
Talk to me about relocation fees. How does that work out?
So relocation fee is different. Under the state guidelines, it's 1 month's rent.
Okay.
Under the city guidelines, it could be as much as $25,000 almost in the city of Los Angeles, and that goes up according to the rate of inflation every year. In Burbank, it's depending on how many bedrooms a unit has, it's so many times the amount of rent times how many bedrooms there are. So there's a formula.
Interesting.
So each city has its own scheme of relocation benefits. And so it's like a patchwork of these laws. And then not every property in every jurisdiction is the same. For example, I could have a single family home in the city of Pasadena, and that's treated differently than if it's a duplex, or if it's a triplex, or in Glendale it's 5 or more units, or it's just a duplex. So, or a condominium. Every kind of property has a different set of laws attached to it. And so you really need an expert on your side in order to navigate these. And some of the people who pass these laws, they don't even know what what these laws are about. They just are asked to sign something.
Makes sense. So who you work with really does matter, basically.
Yes, it does. And just when you think you know the law, you don't.
Interesting. Raymond, let's talk about rent increases, okay?
Yes.
How does it work? What's the limit rent? Is it 4%? Is it 10%? Let's talk about that because every city is different, but I'm curious.
Yes, every jurisdiction is different. Rent increases in the city of Los Angeles are right now capped at 4% if it's under rent control. If it's not under rent control, then it's whatever number that you want it to be, whatever the market will bear. It's important to know that depending on how much increase you want to give, you have to give the appropriate notice in advance. So sometimes it's 30 days if it's 10% or less. But if you're going to raise your rent more than 10%, it's 90 days. So it's very important to know your property, obviously where it's situated, what kind of property is. Again, is it a single family home? Is it a condo? Is it a duplex? When was it built? Even the year it was built makes a huge difference about how much rent you can ask for or how much you can increase. So it's important that you have an idea about your property, and a lot of times it's better before you purchase the property to know what your expectations are, because a lot of times people make a huge investment and then they find out that they can't increase rent or they can't evict a tenant who's a long-time tenant, and there's certain laws that they have to navigate.
So there's a common misconception I hear a lot is landlords say, I own a single-family home, I'm exempt, I can increase as much as I want. Is that true, or is there limits to that too as well?
So the state of California exempts single-family homes from rent control laws if there is no other local law that protects it. Okay. So most single-family homes are not protected by any rent control measures. However, the state of California, when they passed
AB 14.
Exactly. Yeah. So AB
1482.
AB 1482. So when they passed it, they required that landlords notify the tenant that a property is exempt, such as a condo or such as a townhouse, such as a single-family home.
Correct.
So they had a 6-month window if it was an old tenancy to let the tenant know. And if they don't, they might be finding themselves proud owners of rent-controlled unit, single-family home at that.
Wow.
So now some of the new leases have that provision that tells the tenant whether property is under rent control or not, subject to AB 1482 or not, and I'm sure you are aware of it. So it's very important to have realtors who know what they're doing, such as you guys, of course.
Thank you.
And of course, having legal advice from practitioners.
Correct.
To not to make any mistakes.
Correct. You know, sometimes I hear from my clients, like, Mike, I want to increase rent by $500, right? I say, let's analyze the situation. If the single family home is vacant for a month, 2 months, how much is your current rent? Oh, $5,000. There you go. You just lost all the gain that you could have had.
Right.
So you got to be mindful of that as well.
Yes, that is absolutely correct. And again, you
Work with your tenant, keep them happy, raise a little, but you know.
I always tell my my landlord clients that to have a happy tenant, it's like your investment is growing because you don't want your property to sit idle for a long time, because if it's sitting idle, that means A, you're obviously losing all this money that you could be making from rent, but B, a new tenant comes in, they want renovations. You have to bring the property up to speed and all of that. So be careful of what you ask for sometimes. You don't want an increase that's too much.
Exactly.
But one thing that I find, a lot of tenants, as soon as you want to raise the rent, they're like, oh, my water heater is like late in getting me hot water, or there's
Everything comes out.
yeah. Window screens are like torn, stuff like that. But I think to be a good landlord, you don't mind that. That
Exactly.
just grows your investment.
Absolutely. Let's talk about ADUs. Now, how does that impact landlord-tenant laws? Because everyone's building ADUs nowadays,
Yes.
so it's the hot topic.
Yes, ADUs are a very hot topic. One thing you have to understand that the ADU, once you build it in the city of Los Angeles, may make your single-family dwelling into rent-controlled dwelling, because now you have 2 units on a lot, right?
Okay.
So previous to the ADU, it was 1 single-family home on a lot, non-rent control exempt. You build an ADU, right? So now you have 2 units on the lot.
But does it depend on the type of ADU? Like if it's a garage converted or like separate detached 2-story ADU?
Any kind of structure you have on your property that has a certificate of occupancy
Correct.
is a unit.
Correct.
So you have 2 units now. You have your ADU, which with its own certificate of occupancy,
Correct.
and you have your single-family home with a certificate of occupancy. So in the city of Los Angeles, for example, that single-family home that was maybe built in the 40s or 50s, now that becomes a rent control unit. So as long as you're living in it as an owner, you don't have to worry about it. You can exempt it,
Okay.
and you don't have to pay fees. But let's say you move out. You move out to a much nicer home, etc., and you want to rent out your old single-family home now to somebody else. Guess what? That's under rent control. You have to register the property. You have to make sure that the property has no issues, and you're not increasing the rent illegally, etc. So that single-family dwelling that you always thought, oh, I'm exempt, all of a sudden, because of the ADU, it becomes non-exempt. But my personal take on this, it's great. Building units on property is a wonderful thing to do. You are increasing the value, you're
Correct.
increasing the marketability, and I think it's always a plus.
And you're increasing your cash flow too.
Yes, absolutely.
With today's rates, most of my clients, once they build ADU, that's where their cash flow comes in. They break even with the primary residence.
Yes.
And once they have the ADU, they have a cash flow there. Okay. Are there any upcoming legal changes or trends in landlord-tenant laws in LA County?
Yes, one that off the top of my head is security deposits. You cannot ask for, as of I think June,
right?
Yeah, June of 2024. You can only ask for 1 month security deposit, no more 2 months. It used to be 2 months if it was unfurnished, 3 months it was furnished.
Right.
Now it's 1 month.
No matter what, even if it's
No matter
furnished.
what. No matter what. So it's 1 month. So I'm finding that a lot of landlords were not charging 2 months plus a first month security deposit or to enter into a property. They were just saying, just give me 1 month and then pay me my first month.
Correct.
So it doesn't really affect those people.
Okay.
But legally, you could have asked for 3 months total, 2 months plus the first month. But that's going away because it was getting very difficult for a lot of tenants to come up with that much in cash. So the legislation has been passed. So now that's one thing. The other thing is AB 1482. There are going to be changes coming in April. They're going to make it harder for major renovations. So we'll see what happens with that. But one of the things that might change is you have to show as a landlord that you are going to make such major renovations that the place is going to be uninhabitable for at least 60 days, so longer period of time. So you have to get really acquainted with your contractors to make sure that they know what they're saying in the proposals and they can substantiate it. So it has to be major renovations, not just cosmetic remodeling.
Interesting. Good to know. Just cause termination. Let's talk about that. Talk to me.
Yeah, so just cause termination means you have a reason to evict.
Okay.
In the city of Los Angeles, every unit, doesn't matter, single family or 200 units, doesn't matter. All units, you need a reason to evict. You can't just say, oh, I'm sorry, your lease ran out, you're month to month, I want you gone. No longer exists in the city of LA at all for any units.
Even if you want to have, like, say, your mom move in.
If you want to have your parent move in or some qualifying relative, you need to go through a just cause eviction with paying relocation, filling out forms with the city, paying the city some fees, etc., etc. So again, just cause, there's some no-fault just causes and for fault just causes. So let's talk about that real quick. So just cause means you need a reason. Some reasons are the fault of the tenant. Some reasons are not the fault of the tenant.
Let's give our viewers some examples.
So a fault of the tenant is very simple. Non-payment of rent. Correct. That's the fault of the tenant and that's a good reason. Or they're breaching the rental agreement. That's a good reason. That's fault and with a reason.
They have other people moving in, living with them.
Yeah, exactly. They're doing something illegally or breach of the contract.
Correct.
Now, no fault with a reason is something that you just said. What if you have a mom who wants to move in? What if you have a situation where you're going to tear down the property, build condos? Those are no fault because it's not the fault of the tenant that you want to move in your mom or you want to build like a huge complex. But it is a reason. It's a valid reason. And you can evict. You can relocate, actually. So it's not eviction. What it's called relocation at first. Eviction is only when it gets to court.
Okay.
So you relocate the people. You give them their relocation fees. You go through the city. You fill out some forms, et cetera, et cetera. And once you do the process, then the tenant has to leave. In my experience, not all tenants leave after you've done everything according to the law. And a lot of my landlord clients are wondering, hey, I did all of this. Why is not my tenant leaving? I mean, I'm willing to pay them. I fill out the correct applications. Well, legally, only a judge can evict a tenant. You need a judgment. So just because you did A, B, and C with the city doesn't mean that automatically at the end of so many days you can go change the locks and tell the tenant that you got to leave. You still have to go to court to evict them. So
how long is the process?
Gosh, that's a very good question. Everything depends, right? So I would say do not think that you're going to get a tenant out in less than 90 days. I would say 90 days or more. Right now it's taking the sheriff, even with a judgment in your hand, you have a judgment from the court. Just to have the sheriff come and remove a tenant, it's taking about 60 days.
Just the sheriff?
Just the sheriff showing up.
Wow.
It used to be 21 to 30 days. Now, so I've talked to some deputies and they're telling me that because of sheer volume of cases right now, post-pandemic, they just don't have the
manpower. And plus, defunding the police department didn't work out.
Yeah. And there's a shortfall of people who want to be law enforcement officers. The academies are not getting as many applicants, et cetera, et cetera. So that's causing all kinds of issues for us.
So be mindful, because I'm seeing a lot of times investors, the property's on the MLS and listing agent put buyer to assume the tenant, buyer will have to evict the tenant. So be mindful of that, because like you said, 60, 90 or even longer. So
Yes. And sometimes I tell my landlord clients who want to sell, I tell them, you can sell. There's nothing against you wanting to sell, but if it's vacant, it's better. Usually, this better than anyone. But it really depends on whether you can even do that. You may not, as a landlord, may not be able to evict. You have to sell with the tenants in them.
Makes sense. Okay, so I get this asked a lot. Mike, I want you to lease out my property, but I don't want no pets. Absolutely no pets, right?
Yes.
I got to be careful with that. So talk to the landlords out there. How does that work out?
Well, I've had it all. I've had people who say, "Oh, there's a parakeet, and I want to evict because they have a goldfish or something." So, obviously, those are not going to go anywhere.
Correct.
In my opinion, it would have to be a pet that is dangerous, or a pet who is a nuisance, or is causing problems with other tenants. Just having a pet is, I just don't take those cases, because too often they lead to disappointment for the landlord that they can't evict.
But legally, the landlord cannot refuse an applicant.
Yes, as long as it's a disability-based, not an emotional support, by the way. Emotional support animals are not as protected as disability-protected pets. So normally what I tell my clients is that, well, they've toughened the laws a little bit. They've made it better for landlords.
Okay.
It used to be tenants used to go online and just download a note or something from someone saying, "Oh, this is an emotional support animal." Now they've tightened it a little bit. So you actually need to have a treating physician who's treated that tenant for a number of days, like a month, so that it's not just somebody going online and just downloading a certificate and slapping it on and saying, "Oh, I have an emotional support animal." So they have toughened it a little.
Okay. Let's switch gears and let's talk about property damages. Tenant damages a property, they're leaving. You have a security deposit, but the damages exceeds the security deposits. How does the landlord protect themselves?
Well, the landlord needs to protect themselves by, first of all, a lot of luck is involved. What kind of tenant you get is a lot of times luck.
True.
Now, obviously, you want to do some good background checks before they become your tenants.
Correct.
Because I find that good tenants, for the most part, stay good tenants.
Correct.
Bad ones, you see it right off the bat from the first month. You get to see the kind of people they are. But I can tell you that the only kind of relief that a landlord has is to just sue in small claims court for the damages. So take good pictures, get estimates, make sure you do proper accounting, and you mail your accounting with whatever invoices you can get within 21 days of the tenant moving. Sometimes my landlords tell me, "But I don't know where they moved to."
Yeah.
So just send it to the same address, your own property, so last known address. And a forwarding order could be on file with the U.S. Postal Service, so they could get it. So make sure within 21 days you at least do proper accounting of the security deposit, and if there's a shortfall that you ask for it, you demand it, and if you don't hear something back within a month or so, your only relief is to just file a small claims action.
Raymond, what are the best legal practices for landlords when dealing with late or missed rent payments?
Not to let the overdue rent slide for too many days or months. I've had clients call me and say they haven't paid rent for 7 months now, and they keep saying, "Oh, in 2 weeks I'm getting paid. I did some work, so I'm waiting for a check," et cetera, et cetera. It's like a credit card debt. Once you get into a hole, it's almost impossible to get out of it.
Sure.
And it gets worse because every day they're living there, they're getting into more debt with you, right, as a landlord.
Exactly.
So I would say right off the bat, give them a 3-day notice to pay rent or quit, okay? It's very important to get it on file so that in case you have to start an eviction action, you're not too far behind the 8 ball.
Okay.
Because if too much time passes, then all of a sudden you're like, oh my God, I'm so many months, and then more months to get to court and for the case to wind its way. So you have to be very firm in the very beginning. You give your 3-day notice and say, I'm giving it to you because if you pay me, then we're done. We're good. So it doesn't go on your record. Even if you file the case in court, it doesn't go on your record. A lot of people think that, immediately goes on the record. It doesn't. It only goes on the tenant's record after a judgment is entered. And that's way down the line. And there's so many different things you can do. You can seal a case, you can have a settlement, et cetera, et cetera. It doesn't affect the tenant's credit at all. So I think that the common mistake is waiting too long.
Waiting too long. Okay. This was great, Raymond. Is there anything you feel like I should have asked you that I didn't that you want our viewers to know?
Yes. So one thing I have to say, one comment I want to make is don't let what I have to say scare you from investing.
Okay.
It's great to be in the real estate world. Buy property. Call Martin Mike. and don't be afraid. You have to have proper advisement from you guys, from a lawyer.
Correct.
But don't be gun shy about purchasing property, selling and purchasing more property. So don't let what I have to say or what you hear in the news scare you off from investing, because after all, real estate is the strongest investment one can make.
Absolutely. Now, if our viewers want to contact you directly, they have questions, how could they move forward?
Well, they can call my office.
Okay.
My phone number is 323-953-9494. 323-953-9494. My office is in Los Feliz area, but you don't have to come to my office. 90% of my landlord clients do not come to my office. We can do everything either by Zoom or a phone call, and you're more than welcome to give me a call and set up an appointment.
Perfect. Well, there you have it, folks. I hope you guys enjoyed this episode as much as I did. Raymond, it's been a pleasure.
Pleasure was mine.
Thank you very much.
Thank you.
Off to the next one.